People v. Matthew Colpine. It's two files. There's a probation violation, file 24-6906FH, and there's an arraignment in file 26-7179FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
James Gilbert here on behalf of Mr. Colpine.
All right. And for purposes of arraignment, do you or Mr. Colpine wish to have the allegations formally read?
No, Your Honor, we'll waive the reading and Mr. Colpine will stand mute at this time.
Okay, I'm going to plead not guilty on those charges. As a forensic center, well, forensic center has already been completed, right?
Well,
It was completed. Are you requesting any additional forensic center?
that's a perfect way to put it. No, I am not.
Okay. Okay. And it's my understanding the parties may have a resolution of the new case today?
That is true, Your Honor.
Okay. Let me take a look at this affidavit here. Okay, yes. Can you mark this as joint exhibit? All right, Mr. Colpine, would you please, as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Mr. Colpine, a no contest plea has the same effect as a guilty plea in terms of you being convicted of the charge and my authority to sentence you. Do you understand that?
Yes, I do, Your Honor.
What's the basis for the reason for a no contest plea?
He doesn't have much recollection of what happened that evening.
Okay, and Ms. Goodrich, you consent to that?
Yes.
All right. All right, Mr. Colpine, I have to advise you the maximum charge that you could face, or the maximum penalty that you would face. So in this new file, it's a charge of domestic violence, third offense. And that is a felony punishable by up to 5 years in prison and or a $5,000 fine. Do you understand the maximum penalty?
Yes, I do, Your Honor.
Also, you're currently on probation to this court for felonious assault. And that is if you are found to be in violation of your probation by way of that new charge, I could revoke that probation, and the maximum penalty in the probation file is 4 years in prison. Do you understand that?
Yes, I do, Your Honor.
All right. Now, did you read and understand the rights listed on the advice of rights form that you signed?
Yes, I did.
Do you have any questions for me or Mr. Gilbert about any of those rights?
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At this point, the courtroom is entering one of the most critical stages of any criminal case. The defendant is giving up fundamental constitutional rights in exchange for a plea agreement. The judge is carefully making sure every answer is voluntary and fully understood because one mistake here could jeopardize the entire case later. But with a prior felony assault probation hanging over the defendant's head, this decision carries enormous consequences. Do you think accepting this plea is the smartest move, or should he have taken the case to trial? Let's see what happens next.
Do you also understand you have the right to have a hearing in the probation matter where that would need to be proven by a preponderance of the evidence?
Yes, I do.
All right, and the right to Mr. Gilbert helping you at that hearing. You understand that?
Yes.
All right. Has anybody promised you anything to get you to give up those rights today, other than the plea agreement?
No.
Has anybody threatened you?
No.
Is it your own free choice to do so?
Yes, Your Honor.
If I accept your plea, do you understand that you won't have a trial at all and you'll give up all those rights to the trial and the probation violation here?
Yes, I do.
Also, if I accept your plea, you give up any claim that your plea was caused by threats or by other promises. Do you understand that?
Yes, I do.
Also, you lose the right to appeal if you enter a plea. If you wanted to appeal, you'd have to seek permission. You would have to do that by filing an application. And even if the court accepted that application, the types of issues you can raise are very limited if you plead guilty. Do you understand that, Mr. Colpine?
Yes, I do, Your Honor.
This plea agreement provides that in exchange for you pleading no contest to domestic violence third, and therefore admitting that that violates your probation, the prosecutor will dismiss the habitual notice, and there's a sentence agreement for concurrent sentencing, which it would be concurrent anyway, but that clarifies it for you, and that there'd be a cap on 10 months jail in the new file. Do you understand that?
Yes, Your Honor.
Has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you?
No.
You understand, I'm not required to follow that sentence agreement, but if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that? Now, that's unless you were to get in some trouble between now and the sentencing. Even though you're back in the jail, sometimes people get themselves in trouble back then. I'm sure you've seen it happen. So if you were to do that, I wouldn't have to follow the sentence agreement. But you, by your own bad conduct, would have lost the right to withdraw the plea. Do you understand that?
Yes, Your Honor.
All right, Mr. Colpine, then how do you wish to plead in file 7179 to the charge of domestic violence, third offense, guilty, not guilty, or no contest?
No contest, Your Honor.
All right, and I have reviewed what's been marked as joint exhibit, and I do believe that it establishes that on or about October 23rd of 2025, Mr. Colpine did assault one Mr. Gingrich, that was a resident or former resident of his household. Mr. Colpine, as of last October, did you have a prior conviction for domestic violence in 2016 in Sheboygan District Court?
Yes, Your Honor.
And also in 2024 in the Sheboygan District Court?
Yes, Your Honor.
All right. Therefore, and were you in October on probation to me for a felony assault case?
Yes, Your Honor.
All right, so I find a factual basis for the domestic violence third as well as the probation violation. Mr. Gilbert, do you agree?
I do agree.
Ms. Goodrich?
Yes.
Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not, thank you.
And do you believe I fully complied with the requirements of the court rule?
I believe you have, thanks.
Ms. Goodrich, do you agree on both counts?
Yes.
All right, Mr. Colpine, I do find that your plea of no contest is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis, in fact, in law to believe that you are guilty of the offense and that that constituted a violation of probation. So I accept your pleas, and what we're going to do is well, I did, given he's sitting on about 9 months now. Is that right?
As of today, 245 days.
245, okay. I mean, he's already on probation. I don't believe that, especially given the cap and given my understanding of Mr. Colpine's history.
This is a fascinating moment because the judge is revealing exactly how sentencing decisions are made. Although she's clearly concerned about the defendant's repeated behavior, she's also balancing factors like time already served, the negotiated plea agreement, and the overall goals of justice. Notice that she's even questioning whether a lengthy pre-sentence investigation is necessary. That's often a sign the court already has enough information to move the case forward efficiently. Would you agree with giving someone another opportunity? Or do repeat offenses deserve a harsher sentence? Let us know your thoughts below.
Although I'm worried about his continuing behavior, I don't think this is the case that's going to be a prison case for him. And I certainly don't need him on probation any further. I'm just wondering whether we need preparation of reports that wouldn't be necessary. Would the defense waive preparation of a pre-sentence report and probation violation report?
The defense would.
Ms. Goodrich?
I would.
So and I understand that given his credit, Mr. Colpine probably wants this to be scheduled as soon as possible in any event. So by the waiver of these reports, I could schedule sentencing as early as 2 weeks from today, July 21st at 2:30. Would that be fine, Mr. Gilbert?
That'd be fine, Your Honor.
We're going to schedule both of these matters for sentencing and a probation violation sentencing on July 21st at 2:30 in the afternoon. But the court is not going to request a probation violation report or a pre-sentence investigation. All right, anything further from the defense?
No, Your Honor, thank
From
you.
the people?
Yeah, I think we-
Okay, we'll see you in a couple of weeks, Mr. Colby.
Thank you, Your Honor.
All right, we can call Kobe Justin Linden. It's file numbers 24-6886 FH, 24-6887 FH, and 25-6964 FH for probation violation hearing in all three files. We've got Ms. Goodrich for the people, Mr. Gilbert for Mr. Linden, who's present in the courtroom. Mr. Gilbert, do you know how he wishes to proceed today?
Your Honor, in talking with Mr. Linden, is that we're willing to admit counts 1 and counts 2 to the dilute test and the positive.
Okay. All right, and I think given the prior, those are technical violations, but given that I think we've got probably 10 or more prior technical violations, we don't need to get all 4. So the court would dismiss counts 3 and 4 of the violations in exchange for that. Mr. Linden, as best you can, would you raise your right hand for me? Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you can put your hand down. Mr. Linden, you have the right to a probation violation hearing where the allegations would need to be proven by a preponderance of the evidence. The rules of evidence don't apply at that hearing except as to privilege, but you'd be allowed to question any witnesses that are presented against you and to present any evidence that you wanted in your own defense. Do you understand that?
Yeah.
You'd have the right to have Mr. Gilbert help you at that hearing. Do you understand that?
Yes.
Has anybody promised you anything in exchange for waiving your right to that hearing?
No.
Has anybody threatened you to make you?
No.
Is it your own free choice to do that?
Yeah.
You are on probation to this court in file 6886 for tampering with electronic monitoring device, habitual fourth, with a 15-year statutory maximum. The guidelines at the first sentencing were 2 to 34 months. In file 6887, possession of methamphetamine, habitual fourth, with the habitual statutory maximum life, but the advisory guidelines at the first sentencing were 5 to 46 months. And in file 6964, possession of methamphetamine, habitual fourth, statutory maximum life, possession buprenorphine, habitual fourth, statutory maximum 15 years, possession LSD, habitual fourth, statutory maximum 15 years. The advisory guidelines in the top charge in that file at the original sentencing were 10 to 46 months. And I don't know what the guideline, I mean, sometimes that changes. I just wanted you to know the guidelines so that you're not hearing life, you know.
I know.
Okay, there's not going to be a sentence that you're sentencing of life in prison. All right, so do you understand if you plead to these violations, even though they're technical violations, given the number of prior technical violations you've had, I could revoke your probation in all 3 files and you could face those maximum penalties that I outlined?
I understand that, Your Honor.
Okay.
I just hope that, if I can speak, that I did have 13 months sobriety, and I've been open, honest, and willing to proceed as best I can to do the best I can in this program, and I was honest with you also.
Okay. I mean, I'll take all those things into account of the sentencing, Mr. Linden. All right. All right. Knowing all these things, the rights that you have and the maximum penalties that you face, how do you wish to plead to the allegation in count 1 that you violated probation by submitting a dilute sample?
Oh, you're guilty.
And how do you wish to plead to the violation alleged in count 2 that you did use the controlled substance methamphetamine?
Guilty.
So, Mr. Linden, Were you on probation to this court for all those charges and participating in the recovery court program? And as part of your probation and the rules of that program, were you required to not use or possess controlled substances? And were you required to submit valid urine samples for testing?
Yes.
On or about June 8th, did you submit a urine sample for testing that was invalid because it was too dilute?
It was, but also Harbor Hall had, in Emmett County had problems going on where I wasn't the only dilute in the recovery program. And I know that there's others with me that had them that didn't get in trouble for them.
Okay. All right, well, and everybody's got their own
I
path
understand.
through that, and it's based upon the number of prior violations as well.
After I talked to Nicole, she told me that they weren't going to even be allowed to drop over there anymore, so I don't know.
And on or about June 16th, did you use the controlled substance methamphetamine?
I did,
Okay, and you knew that you had consumed that substance?
yes.
Mr. Gilbert, you satisfied with that factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, are you aware of any promises, threats, or inducements beyond the court's dismissal of counts 3 and 4?
I am not.
Ms. Goodrich?
No, Your Honor.
All right, Mr. Linden, I find that your plea in all 3 files, then it's the same allegations in all 3 files, is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you have violated your probation. And so I do so find indicate that these are technical violations, but that there's been more than 4 of them. So I'm going to schedule this for a probation violation sentencing, and I will refer it to the Department of Corrections for a probation violation report to be prepared so they can make recommendations. So we all know what their recommendations are so that we can, then I'll hear from them. I'll hear from you. I'll hear from the prosecutor before I make a decision about what to do. Would we be able to get that done for the August 4th, you think?
Yes, Your Honor.
Okay. We'll schedule it for August 4th at 2:10 in the afternoon. Hearing further from the defense,
No, Your Honor, thank you.
from the people.
No, Your Honor, thank you.
We just will see you August 4th at 2:10 in the afternoon.
Today's hearing demonstrates how probation violations can dramatically change the direction of a criminal case. In the first matter, the court accepted a no-contest plea to felony domestic violence and scheduled sentencing after waiving additional reports. In the second case, the defendant admitted multiple technical probation violations, leading the judge to order a probation violation report before deciding the appropriate sentence. Rather than rushing to judgment, the court gathered the information needed to make a fair and informed decision. If you found this courtroom breakdown insightful, don't forget to like this video, share your opinion in the comments, and subscribe for more real courtroom analysis and jaw-dropping legal cases every week.